So in this last podcast, we're just going to finish off the legislative obligations in family law. Then we'll go on to look at confidentiality and admissibility of statements made during family mediation, and then we'll look at issues of family violence in mediation. So we finished off in podcast 2 talking about section 60J, and that lawyers, even if there are issues of violence or abuse, still have obligations to talk to their clients about ways to settle their matters before going to court. And we also said that in some of these sorts of matters, mediation may be appropriate. It's just a matter of setting it up in an appropriate way. In other matters, it won't be appropriate. And this is really the role for the FDRP, the family mediator, to determine when they conduct an intake, which is when, for example, the first party approaches them, says, please organise a mediation, or the party's lawyer approaches them. They then contact the other party, see if they're interested in mediation, and if they are, they then conduct an intake to work out what the issues are, what the history is, how the parties are going, are there any issues of violence, abuse, or safety. Generally, are there any issues that mean that one party may not be able to negotiate effectively in a mediation? For example, another sort of issue might be that a party has impaired mental capacity and that they're not able to negotiate on behalf of themselves, and whether they have a guardian that can act on their behalf in the mediation. Now, we said previously that Federal Circuit Court can make orders to mediation. The Family Court of Australia can as well, and this is under the Family Law Act, Section 13C. The court can order, or this is the judicial officer, can order the parties to counselling, mediation, or to participate in an appropriate course, program, or service. Now, other types of courses that they may order them to participate in are parenting orders programs. That is when the court has made a parenting order about children, and the court then orders both the mum and dad to go to a parenting orders program. It's administered by a community service. They would attend separately to information sessions about how to work to collaboratively co-parent after their separation, and also how to make sure that they bring their parenting orders into effect and that they comply with their orders. Other types of programs could be a domestic violence perpetrator program, or a client, for example, in a family court might get ordered to undergo a psychiatric assessment. So the court can make all those types of orders. And have a look at Section 13D of the Family Law Act, which talks about the consequences if the client does not comply with the order. Now, just to clarify, as we said before, for a family mediator to be able to issue a Section 60I certificate, they must be accredited and registered with the Commonwealth Attorney General's Department. To do this, they have to undergo quite intensive training. We offer that training here in the QUT Law School. They are contained in master's units, and they are also run as short courses. And I'll put information up about those courses on our Blackboard site at the top of Learning Resources. Now, remember that people have to attend mediation. They get the certificate from the family mediator. They then, if they can't resolve their dispute and they decide to make an application in court, they file the certificate, the Section 60I certificate, with their application. If they are saying they fall under one of the exceptions and they don't need to attend mediation, they file an affidavit setting out why they don't need to attend and how they fall within one of the exceptions. For example, urgency or issues of violence, and have a look at the exceptions there in Section 60, capital I, subsection 9. Now, the types of certificates that the FDRP can issue are set out in subsection 8. They can, for example, if one party approaches them and the other party is interested in attending mediation, but then they conduct their intake, they might find that the case is not suitable for mediation, that one party will not be able to negotiate effectively, and in that case they can issue a certificate saying that FDR, or family dispute resolution, is not appropriate. Also, one party might want to attend mediation but the other party refuses. In this case, provided that the FDRP has made reasonable attempts to organise the other party to mediation and inform them of the possible consequences if they don't attend, the issuing of the certificate, and they can issue a 60I certificate that says that one party would not attend. Also, while the mediation is in progress, the FDRP might decide that it has to be terminated. This could be, for example, if one party is not genuinely mediating. They might be hiding something from the other party. For example, in a private meeting, they might say, well, it doesn't matter what happens in the mediation. They're about to take the child overseas to another country. In that sort of circumstance, the mediation must be terminated because they're not genuinely participating and they're not being honest in their negotiations. Now, we talked about the need for people to make a genuine effort, and we said that there is no definition in the Family Law Act of genuine effort. Hilary Astor has proposed that genuine effort may mean attending the mediation, being willing to put forward offers of settlement, being prepared to consider offers of settlement, and a willingness to focus on the needs and interests of children. Now, the Attorney General's Department have also given us a suggested definition, and this is on page 156 of the Family Law Principles text, and it says, genuine effort should be given its ordinary meaning in the context of the Family Law Act. A genuine effort involves a real, honest exertion or attempt. It must be more than a superficial or token effort, or one that is false or is pretense. The effort should be one that is realistically directed at resolving the issues that are in dispute. The question about whether a genuine effort has been made will depend on the circumstances of the case. It is a matter for the professional judgment of the FDRP. Whether the issues in dispute are resolved or not will depend necessarily on the circumstances of the case, and there may be valid reasons why people have differing views on an issue. And what they mean by that is, for example, normally we would think of a genuine effort as being compromise, and that someone is prepared to compromise from their initial position. But sometimes people do, not do that, but we might assess that they've made a genuine effort because we think that their initial position is reasonable in view of the circumstances. For example, if one parent truly believes or genuinely believes that the other parent will not care for the child properly or has abused the child and the child will not be safe with them, we might assess that they have made a genuine effort even though they will not budge from an initial position of supervised contact. So it is a bit of a difficult area, and sometimes difficult when you're a mediator to assess whether someone has made a genuine effort. Now, if they haven't made a genuine effort, under Section 60I-8, the court can take this into account if the case ends up in court. For example, they could make an order for the parties to attend mediation again, or if one party has refused to attend, they can order the parties to attend mediation. Also, in theory, it is open for the court to make a costs order against the person who didn't attend and make a genuine effort. However, in practice, family courts very rarely make costs orders, and a costs order is paying the legal costs of the other parent. They're very reluctant to do this. I haven't heard of a case where they've done it in this sort of circumstance, but please know if you have. Now we're going to now move on to confidentiality and admissibility in family resolution. Now this is in the context of the role of the family mediator. Generally, what is said by parents and clients in a mediation is confidential. The mediator can't reveal it to other people or to authorities such as Department of Child Safety, police, and the statements that parties make in family mediation cannot be raised in court or put into court affidavits, for example. But under sections 10H and 10J, there are some limited exceptions. And there are similar sections in relation to parties attending counselling and what statements a counsellor can reveal in sections 10D and 10E. Now under section 10H, this confidentiality has in the case law been limited to while the mediator is actually conducting the mediation, not during intake. And the case law has told us that statements made during intake or notes made, and there is one case so far, I think it was a Federal Circuit Court case, that said that statements made by parties during intake and notes made by the family mediator are not confidential and will be admissible in court. So that's one of the exceptions. Another exception is a family mediator must disclose something said by a party if they're required to by law. Further exceptions is one of the parties consents. So for example, if there's if a person consents to you telling someone something that was said in a mediation, that's okay. Probably the main exception that comes up in practice is this subsection 4. This means that if you're in a family mediation and one of the parents discloses, makes a statement, and it would be necessary for you to report it or to tell another person to protect a child from risk of harm, prevent or lessen a serious and imminent threat to the life or health of a person, and note that's a serious and imminent threat, report the commission or likely commission of an offence, prevent or lessen a serious and imminent threat to the property of a person, report the commission or likely commission of an offence involving damage to property, or if it's information necessary to tell the independent children's lawyer, who is the lawyer acting in behalf of the best interests of the child. So if anything, any misstatement is made by a party along those lines, the mediator can tell someone else outside of the mediation and can report it to an authority. For example, if one parent threatens the other parent in a way that you think is a serious threat, and perhaps that's in a private meeting with the parent that makes the threat, you can then tell the other parent that the threat has been made too. You can also report it to the police. I guess often in mediations the independent children's lawyer actually comes along to the mediation. So what some mediators do is they have them present in the open session with all parties and then in the private meetings between the mediator and the client. So that's really a matter of the convention of the mediator. Now the admissibility section, section 10J, deals with whether statements made by parties in mediation will be admissible in court. That is, can they be brought up in court, and can any notes made by the family mediator be subpoenaed and then used in court. Now this section is much more limited than the previous section. Note that it doesn't deal with threats made. There has been case law about that where a threat was made by a father to a mother in a private meeting with the mediator, the mediator could tell the other parent under Section 10H, but it could not be raised in court because it doesn't come within these exceptions in Section 10J. So I guess the main exceptions here that are relevant is that if a party says something and it indicates that a child under 18 or has been abused or is at risk of abuse, or a child makes a disclosure in a mediation where a child might be interviewed by a family consultant, those sorts of matters are admissible in court. So you'll see that that's much more limited. Now, another issue that has come up is whether a parenting plan made at the end of a mediation is admissible in court. The better position seems to be that it is, provided that the parenting plan is a valid parenting plan. So what that means, I guess, we also have Section 131 of the Evidence Act. And Section 131 of the Evidence Act says that if people are making offers of settlement and counter offers, that is not admissible in court. That's confidential. But there's a distinction drawn between offers of settlement and negotiations and then the final agreement, if there is an agreement reached, which is drawn up. So in family court matters, the final agreement, when it's drawn up, will be admissible. And the cases indicate to us that if it's a parenting plan, and we'll be talking more about parenting plans in our module about children, if it's a valid parenting plan, it will be admissible and can be used in court as evidence of the agreement the people made. And the context of that is usually that they've made an agreement, they've written it up into a parenting plan, but then one of the parents hasn't reneged on the agreement. We'll see in our children module that there are certain requirements for a parenting plan to be valid. It has to be in writing, signed by both parents, and in particular it has to be dated. And for example, if it's not dated and not signed, it won't be a valid parenting plan and it won't be admissible in court. Now, I did before just touch on this concept of intake. So for a family mediation, it's required under the Family Dispute Resolution Regulations that I've put on the Blackboard site that the Family Dispute Resolution practitioner conducts an intake with the parties before organising the mediation. In Regulation 25.2 of the Family Dispute Resolution Regulations, it sets out what the family mediator has to assess in this intake session. So it says they must make an assessment of the parties so that the parties are able to negotiate. And I guess that's looking at whether there are any concerns about power imbalances, particularly coercive controlling violence, which we'll talk about in a minute, concerns about mental health. Sometimes people can become very depressed after separation, or they can have a particular mental health problem that was pre-existing the separation. Also, that family dispute resolution is appropriate in the particular context of that case. So particularly what the mediator has to look at is whether the ability of each person to negotiate freely is affected by issues of violence, safety issues, which would also be linked to issues of violence, equality of bargaining power. That can come up also for where there are cultural issues. For example, in some cultures, or for a particular couple, it's not appropriate, for example, for a wife to challenge her husband. There can be issues of bargaining power if it's a mediation between a grandparent and a child, for example, where a grandparent has cared for the child of their child. There can be some power imbalance there. Where there are issues of child abuse, Also looking at the emotional, psychological and physical health of the parties. For example, there could be a physical disability. That means it will be difficult for someone to participate in a mediation. Also, the mediator can look at if there are any of those issues, would it assist for the party to have a lawyer represent them? Can that be arranged? Can they get a legal aid conference? Are they entitled to legal aid, or can they pay for a private lawyer? So sometimes some of those issues can be overcome too by having a lawyer at the mediation and assisting you to negotiate in the mediation. Now, I said before that there has been a case that says that intake is not confidential and admissible. Anything said by the parties in intake and any notes taken by the mediator are not confidential and can be used in court, and that's the case about a Rastel and Ball. And that was, well, it was actually a Federal Magistrates Court decision. The Federal Magistrates Court is now called the Federal Circuit Court. Now, when the mediator is assessing all of these issues and whether people can freely negotiate, there is a screening tool that has been developed called the DOORS program. Now, I guess that's more relevant for family mediators, but have a look at that. And actually, I'll just take that out. That's not correct. We don't have our workbook this semester. Just have a look at that if you're interested. You don't need to look at that if you don't, but it's just a tool for family mediators to use, and it can also be helpful for family lawyers to get a bit of an idea of, well, what sort of matters for clients should they refer to mediation and what sort of matters may not be appropriate. Now, when we talked about coercive controlling violence, I guess this really comes from an article by Kelly and Johnson, which I have put on the CMD. And the article's title is Differentiation Among Types of Intimate Partner Violence. Now, this article and the different categories is controversial, and not everyone would agree with it. And I have to say the most controversial probably part is the category of violent resistance, which is, say, if a person is being physically assaulted by their partner, that they then defend themselves, and in defending themselves or in getting angry with the partner, that they are then violent towards their partner. However, the relevance of this article to us is that they really highlight the coercive controlling violence being the one that is a particular problem in mediation. Sometimes when couples separate, there can be an isolated incident of violence and high-level abuse. The sort of relationship's been breaking down, it comes to a head. There can be one incident in which there might be violence, including verbal abuse. And that's quite different from coercive controlling violence, where it's really about one person having power and control over the other party. Now, Kelly and Johnson say that for other types of violence, for example, the situational couple violence that I just talked about, oh, and actually, sorry, what I just talked about is probably separation instigated violence. That might be okay for mediation, but the particular problem is this coercive controlling violence, which is sometimes characterised by one party wanting to know where the other party is all the time, checking up on them, sometimes thinking that they're having affairs and being very jealous, sometimes really controlling what money they have to spend, when they can leave the house, whether they can work or not. That can be quite difficult for the victim of this violence to participate in a mediation, because they then sometimes become locked in this relationship. They can't get out of the relationship. They're frightened too. They feel if they leave, they will be in a lot of danger, which is sometimes the case, that for a partner who is very controlling, they don't cope very well if the other party does leave or attempt to leave, and they can sometimes become more violent and abusive, or sometimes there can be a very critical incident that we do sometimes see in the media. So just be aware of that. I guess you don't have to read that article if you aren't interested, but it's just really for people interested in that area. Now, the very last thing I'll talk about in this podcast, and only very briefly, is that we did have 2011 amendments to the Family Law Act. We will talk a little bit more about that in later modules, but the main impetus behind those amendments were to provide more protection for victims of violence and victims of abuse. And concerns were that there had been quite major amendments in 2006, and I guess that was really to promote the presumption of equal shared parental responsibility, and also in 2006 those amendments introduced the compulsory mediation in parenting matters except in exceptional circumstances. Now, what that led to for some people was that people were then attending mediation after 2006 amendments when it was inappropriate. For example, even though there were the exceptions where there are issues of violence, people either didn't know about that, or they felt that the court might think of them negatively if they didn't go to mediation. So the research post the 2006 amendments highlighted that this was a problem for some families, and also for some parents that they really felt coerced into a shared time parenting arrangement. Although there wasn't a presumption of shared time, there was a presumption of equal shared parental responsibility, which is about equal decision making in relation to major long-term issues, that the perception of the community was that there was a presumption of shared parenting. Now, I won't go into that in more detail now, as we will talk about that in detail in the children's module, but just be aware of these major amendments in 2006. For this module, the relevance is the introduction of compulsory mediation. Even though there are exceptions, sometimes people who shouldn't have been placed in mediation were either attending or being told to attend mediation, for example, by their lawyers, and that this sometimes led to people entering into agreements that weren't appropriate for them and their children, particularly where there were issues of violence or abuse. And actually, something that was relevant to that I will just mention is there was what we called a friendly parent provision brought in by the 2006 amendments that was then removed by the 2011 amendments, but it was something the court had to take into account was whether a parent was facilitating contact with the other parent. Now, this meant that some parents, where they did have concerns about safety and welfare of their children, were letting another parent have, for example, unsupervised time when it was not appropriate. So we will go into that in more detail in the children module, and also in the module about social science research. Okay, well, that's all for that series of podcasts, and make sure too, if there's anything you need clarified, you either contact me or bring along queries to our in-person workshop in week 4.